This is Mr. Valentine, whose matters, I believe, are at the end of the calendar, numbers 26, 27, and he has declined counsel and would like to proceed on his own. I believe
So
my office had been this matter before.
Yeah, Mr. Valentine, you had an attorney appointed and then you didn't come back the way we needed to come back way back in March. So you got an attorney sitting there, an experienced criminal defense attorney, might help you. Would you like to take the advantage of having Thurston County Public Defense represent you again?
No, ma'am.
Can you tell me why?
Because I would like to proceed sui juris, because I believe I have my best interests, and I don't think anyone else in this court has my best interests for me.
Buckle up, guys. Today we're diving into a felony theft case where the defendant strolls in late, slouches, and literally falls asleep during court. Judge Middleton spots it immediately and shuts it down. No sympathy, no delay. With $8,000 missing and a plea deal hanging in the air, the courtroom goes from passive to pressure-filled in seconds. What starts as a routine hearing takes a sharp turn, and the storm is just beginning to roll in.
All right, well, first, there are a couple of warrants. I'm going to turn to the prosecuting attorney, Mr. Abid, first, and see what their recommendation is on this warrant return, and then I'll turn to you. So I'll just allow you to represent yourself today as you want to. Mr. Abid?
Your Honor, the state would object to releasing Mr. Valentine, and the alternative, the state asks that the court set substantial bail on both of these matters. The first one, ending in the cause number 693, is a case, is an old case. Mr. Valentine, I'm seeing, has substantial failure to appear history. This is here's sorry, Your Honor. Mr. Valentine was on warrant status for a significant period of time. In March, the court issued a $15,000 warrant on each case. The court, Your Honor, or the state, Your Honor, asks that the court impose bail in the same amount as the warrants.
And this is first DUI from November of 2021, and then the second allegation, January of 2024.
Correct.
And were these, one, it appears, was an allegation of a breath sample of 0.14, and the other from 2024, do you know the allegation?
My notes show that the 2024 allegation was included a refusal.
Okay. All right. So, Mr. Valentine, what the state's asking me to do is have you post about $30,000 cash or a bond bail, and consider those same restrictions that were on you before, that you show up at pretrial services, that you stay clean and sober, you stay law-abiding, you give UAs, you be on a device that's attached to your person to make sure you're not consuming alcohol. What do you have to say?
I object to that, Your Honor. I did make my best effort to show up at court, even when I didn't show up, because I was confused about the dates. The clerk told me the wrong date. I showed up. I gave the clerk a letter. I wrote a letter to the court, and I also wrote counterclaims and responses to the state attorney general's office, and I got no response from either. I went to try to squash the warrant. They told me that they wouldn't squash the warrant. They wanted me to either turn myself in, or they wanted to get me to pay more bonds. I have absolutely no problem showing up and representing myself. As far as what was the next thing? As far as these charges that are against me, I wanted to be clear that I am not a person. I'm not a legal entity. I'm a living man, and I want to enforce my constitutional rights. I have the right to drive without a license. I don't need a license. The Supreme Court has proven that many times. And it is also my understanding that this is a Nisi Prius court, and I would like to implement Rule Nisi. If the prosecutor has a valid contract between us, I would like him to produce it. If not, I do not wish to contract with any member.
All right, guys, things escalate quickly. Weller may seem laid back, but the charges on the table are deadly serious. The judge lays out his record, multiple felonies, habitual offender status, and now larceny of over $8,000. That's prison time, possibly decades. Yet, right in front of him is a lifeline, a deal to drop everything to a misdemeanor. Sounds generous, right? But as the judge warns, this is Weller's final shot. One misstep, and that door slams shut forever.
Mr. Valentine, I'm going to hold you on 15,000 cash or bond bail on each of these independently. So you'd have to post bond to be released, as I find that you're a risk to reoffend and a risk to commit, another DUI or vehicular assault or homicide, given the history while under the influence. So you're a danger to the community is what I'm finding. And you don't come back when we order you to come back, and you don't comply with court orders. So 15,000 cash or bond has to be posted on each one of these separately. And then you have to get yourself into pretrial services within 48 hours of release and have a scram device attached, stay clean and sober, stay law abiding, in order to stay out of custody. No alcohol, no marijuana, no non-prescribed drugs, no bars or taverns, and don't drive unless you have a good license and proof of insurance. I'm going to set another court date. We would do this.
What jurisdiction is this court operating under, Your Honor?
Thurston County District Court here in the state of Washington.
Well, what jurisdiction are you trialing me under?
What jurisdiction? Thurston County District Court, Thurston County, state of Washington.
That's not what, is this under a common law jurisdiction?
I'll have you research all that yourself, sir. I'm not going to argue with you. I have jurisdiction over you and over this matter.
So is this court operating common law, ma'am?
I'm talking to my clerk. 1 second. And make it clear, good, that he's proceeding pro se and that we need to do.
I am not pro se. I'm a serious jurist.
All right. You're proceeding without an attorney.
Did you take an oath to uphold the Constitution of the United States, ma'am? The supreme law of the
I
land?
sure did. I take it every time I get reelected, and I take it very seriously.
Will you be honoring that?
Very seriously.
Are you going to be honoring that
No,
oath
it's
today,
just
ma'am?
free trial, and then we'll get it set for confirmation and jury dates.
Are you honoring that oath today, ma'am?
I sure am. And I do it every day.
So you think I'm a person?
I sure do.
So you think I can be bought and sold and regulated? You think I'm a persona, that I live in the likeness of another?
You better hope she thinks you're a person, because objects don't have rights under the Constitution.
I think you're a human being and you're covered by the laws of the state of Washington.
A human being and a person are two different things.
No, I'm not interested in semantics. So
I'm trying to get down to the
you
facts, ma'am.
you can define things the way you want, but the law is not agreeing with you. All right, we're going to be back on September 20th, 1:30. We'll probably talk some more about your decision to represent yourself, and that's fine. But don't be surprised if whichever judge is there has another discussion with you about that. And at any time, you can ask the court to appoint an attorney. Anytime you can hire an attorney to represent you too. You're not prevented from that.
An attorney.
So we'll be back on September 20th, and you need to be back in court. If you're still in custody, we'll hear you in custody. And if you do post bond, you have an obligation to get into pretrial services within 48 hours and comply with them for sobriety monitoring. And that substance use monitoring program will pay for the scram device.
Can we change the venue, ma'am, for lack of jurisdiction?
Well, you'll have to file all your motions in writing, and then you serve them as well on the prosecuting attorney, and then we'll set motion hearings.
I don't have the resources to do that in custody, man.
I think you do.
I don't. There's not much paper here. There's no computers I can use, no printers. They're not giving me post stamps.
Offering you Thurston County Public Defense's assistance, I could.
Deny the right to defend myself. You want me to hire someone else to do it? I'm of sound
I'm
mind
not
and body.
denying that, and I'm not going to argue with you, sir. So, at any time, we can talk about standby counsel and talk about counsel.
Everyone represented. I will continue to proceed sui juris.
All right, that's up to you. All right, so we're done today, and those orders will be given to you in the jail.
All right, I don't consent to any of the
Weller's defense. A bizarre story that the stolen money simply appeared in his account, sent by a friend using a stolen phone. He plays the victim card, wrong place, wrong time. But Judge Middleton and the prosecutor aren't having it. The details don't add up, and his story unravels fast. With every sentence, Weller backs himself deeper into a corner. What's worse, he doesn't even seem to realize it. You can feel the patience in the courtroom wearing dangerously thin.
So I'm guessing you're all here for the same case, since you're all sitting shoulder to shoulder. What case are you here for? Okay. And Ms. Moore, is Mr. Valentine, is that Mr. Valentine with you by chance?
Yes, it is.
This is Mr. Valentine,
Okay.
Your Honor, wishes to proceed without counsel.
Okay.
First of all,
Yeah,
I would like
hold on. I'll let you know when I need to hear from you.
okay.
So Ms. Moore, has your office appointed somebody to replace Mr. Gaslin?
Your Honor, we were not appointed at the last hearing, and I'm not asking for appointment today as Mr. Valentine is declining representation. I have
Okay,
advised.
well, okay,
He wants
I'll take care of it. Thank you. Mr. Valentine, as Ms. Moore has indicated, you've told her you want to represent yourself. I'll tell you, that's a huge mistake. I will treat you like you graduated from law school. I'm going to guess that because you're sitting there next to Ms. Moore, you have not graduated from law school, but you will be treated as if you had, which means I will expect you to know everything that I expect every lawyer to know. I will expect you to do the things that I expect every lawyer to do. I will expect you not to do any of the things that a lawyer is expected not to do. All that means that you haven't been trained in those areas, and yet I'm going to hold you to those standards. You would be making a bad mistake if you represent yourself, particularly because with two cases like this, you're probably looking at potentially up to 2 years in jail. So it's really important that you have good representation. If you were there, even if you had been trained as an attorney, I would say do not represent yourself. Lawyers know not to represent themselves. And there's a saying among lawyers that if you ever get charged with a crime, lawyers will say, it's a fool who represents himself. That is, even though they're trained to do that. So I would strongly recommend you not do that. You have the right to do it. I'll be very clear. I think you would be making a huge mistake should you do that. Do you have any questions about that? Do you have any questions about that?
Are you in?
Do you have any questions for me? Other than that? No, I'm not in tempt. I'm trying to make it very clear to you that I think it's a big mistake.
I'm ready to proceed.
Okay. All right.
First of all, I would like to address we the people, and I would ask that they would all stand for a moment.
Here's where it all starts collapsing. Weller says he only got $500 out of the stolen $8,000 and lost the rest at a casino. His justification: it was part of an inheritance. The judge leans in, confused, annoyed, and disbelieving. The contradictions pile up. How can it be an inheritance if it was someone else's money? Weller spins in circles while Judge Middleton calmly rips through the nonsense. It's like watching a bad poker bluff get called in front of the whole courtroom.
No, We're not doing anything like that. We're here on a pretrial. You have a confirmation hearing set for the 18th of October. Mr. Valentine, you have anything to say about that status? Otherwise, we're just going to close the hearing and move to that date.
I'm going over judicial notices that I've submitted to the court.
Okay. This is not a motion hearing. This is just a procedural hearing. And we'll just close out this procedure or this proceeding and confirm that your next court date is the 18th of October. If you wish to file a motion, you're going to have to do so in the appropriate fashion and get it before the court. It's one of those things that I've told you. It was why I advise you not to proceed representing yourself.
I have filed judicial notices with the court.
Okay, thank you. We'll set a motion hearing and have...
Timeline, 7:12 to 9 o'clock now. It gets cold. Weller casually shrugs off the restitution like it's no big deal, whatever he says. The judge pounces. With a raised voice and visible frustration, Middleton tells him exactly what that money meant to the victim. It's not just about jail time. It's about accountability. Then, in a powerful contrast, the judge arranges bus passes so the victim can return to court. It's a brutal split screen. Weller's indifference versus the court's pursuit of justice.
Hi, folks. I don't want to hear any comments. None. So 18th of October is when he's due back.
And that's set for trial confirmation, Your Honor?
It's set for trial confirmation.
Thank you, Your Honor.
And Amy, if you'll make a note to...
Well, I object to that. You're not allowing your...
Well, no.
Watch closely. This is where it turns. The judge asks how Weller got to court. Turns out he may have driven himself, even with a suspended license and reckless driving history. Middleton doesn't miss a beat. In a calm but surgical move, he revokes Weller's bond. No shouting, just the swift drop of the hammer. You can see Weller's smirk vanish. The courtroom becomes dead silent. The message is loud and clear. One bad decision and the deal is off the table.
Unmuted.
Yes, ma'am.
All right. So, there are a couple of attorneys sitting behind you from Thurston County Public Defense. Did you want the court to appoint counsel or not?
No.
Were you going to hire your own attorney on the matter or represent yourself?
I've made it clear throughout all these proceedings that I'm proceeding sui juris.
Okay. I just need to always make sure of that. We've got confirmation set for the 8th. What is it today that you want to do?
I wanted to argue in some motions that I submitted to the court. A motion to dismiss, a judicial notices that I've dismissed about misconduct of the court and denied of access to the court. And I believe a motion to strike as well.
Motion to strike what?
It was a motion to strike. You guys had served a motion, no testimony to my house. I'm not sure what that was. The motion was never served to me, and the docket was never served to me either. It was mailed to my home. I'm not sure why, because the state was aware that I was in custody, but that's what my motion to strike was pertaining to.
Okay. Well, this is your motion today, and motion no testimony just means we didn't expect to see witnesses being called to the stand. So let me hear from the prosecutor here.
It's
Mr.
the state's
Weston?
understanding that the motion to request discovery and the motion to dismiss was heard on October 28th in front of, I believe, Judge Buckley, and he dismissed those motions. And the state's understanding is that the only motion that was going to be argued today was whether the court should grant funds for Mr.
Tension peaks as Weller scrambles, trying to protest his bond being revoked. But Judge Middleton shuts him down hard. You pled guilty to stealing $8,000. He reminds him, you're not presumed innocent anymore. The words hang in the air like a final verdict. Weller's confusion turns into stunned silence. No more bargaining. No more loopholes. The court's patience is gone, and Weller learns far too late that fake stories and indifference don't work on this judge.
Real quick, Your Honor.
Since the last hearing is what I was looking at. So there was,
Yeah, I objected to his denial of those motions as well because I already submitted an affidavit of prejudice and he disqualified himself. So he shouldn't have been making any judgments on the case after that point. He also said himself that today was going to be a special motion docket where my motions were going to be heard today.
so what I reviewed is what was filed after the 18th. And that was October 21st. I have a request to release you and your request, I'll go back, or let me get back to your court to dismiss these charges, motion to release you. And that's what I reviewed. So is there something else pending that I was not aware of after the 18th?
On 18th, on this October 18th, there's one that says in Laserfish motion to request discovery, parentheses 020, parentheses. In that one, that's based on the state's notes. It shows that that was the only motion that was going to be argued today.
All right, Mr. Valentine, it looks like I need to go back and kind of review real quick those issues. I thought they were all heard on the 18th. And either you can just sit right there while I read everything here, or which is probably the best thing to do. So let me just review all that you've filed here again. Then I'll turn right back to you. So just hang in there. So just before I get to everything, Mr. Valentine, motion request, I guess you titled it to request all of the discovery in this case, but you say that it seems to me, maybe I'm misreading one, that Michael Valentine had an attorney in the early stages of the hearings. Is that just a fact? Or are you asking the court to appoint counsel?
I'm stating a fact that at the beginning of these proceedings, I was working with an attorney.
And then they never gave you the discovery. Okay. All right.
Yes.
All right. All right. Get it.
That's the
Thanks.
state's understanding as well, Your Honor.
All right. I've had some time here to re-review and review what's been filed in the court file from the 18th of October on forward. As to your motions from the 18th on forward and the docket and your pleadings. So as to discovery, let me direct first to Mr. Weston on behalf of the state. Has all discovery been provided to Mr. Valentine?
Correct, Your Honor. So on October 18th, 2024, Judge Buckley ordered that the state provide Mr. Valentine discovery. 5 days later, DPA Thompson himself drove to the jail and delivered all discovery material to Mr. Valentine, which included the citation, police reports, an offer sheet from our office, thumb drives of dash cams, and then the request forms.
The final nail lands quietly but firmly. Weller is escorted out, bond revoked, plea entered, and sentencing. Date locked in. There's no drama, just consequences delivered with icy precision. Judge Middleton never loses control, but you can tell he's done with the games. In the end, it's not the charge that destroys Weller, it's his own attitude. A case that could have ended with mercy now ends in custody. If you enjoyed this breakdown, like the video, subscribe to the channel, and we'll see you in the next one.
Thumb drive that he could view those, a request form for the dash cams. What does that mean?
That when there's a dash cam involved, such as here, our office generally has to send out a request for that dash cam, and that form is just a request asking Washington State Patrol to disclose their dash cams to us.
Okay, but you provided a thumb drive that had those dash cams.
Correct, Your Honor. Thumb
All right.
drive of the dash cams.
And all this information is what the state intends to use in trial against Mr. Valentine.
Correct, Your Honor. Based on the subpoenas that I looked at recently that were sent out for trial, the trooper that's testifying is one of the troopers that is testifying. His dash cam would be on this drive. The police report of that trooper would have been provided in this discovery packet as well. All the information that we would be using at trial would be was in this discovery packet that was provided to Mr. Valentine on December 23rd.
Was it provided before this at any point?
The state is unaware on whether it was or not. The states had the belief that defense counsel, who was previously representing Mr. Valentine up to a certain point, would disclose such materials to him when the court found that when the court allowed Mr. Valentine to proceed pro se. But this state doesn't know why it wasn't provided to him from the prior defense counsel. But upon realizing that Mr. Valentine did not have the discovery packet, the state did provide such material at that time.
And on the witnesses that you're expecting to call to testify, the substance of their information is included in that discovery?
I would believe so, Your Honor. Based on the subpoena that was sent out, one of the witnesses are Trooper Benjamin Crabtree, one of a dragger technician, and because there was one of the charges is driving while license suspended, there is a DOL representative that it will be a witness in the trial as well.
It looks like a witness list was provided while Mr. Gasling was Mr. Valentine's attorney back in the beginning of the year, at least March, I believe it was. So then, Mr. Valentine, as to that discovery, you thinking you're missing something or you should have something else in discovery?
No, ma'am, I didn't receive the discovery in a timely manner. Counsel was ineffective in the discovery footage or the reports with me. I asked on multiple occasions to obtain the video so that I could build a proper defense. And they told me on multiple occasions that it had to be approved by the prosecutor and redacted, which never happened. I waited and waited, never happened. And after counsel's ineffectiveness, this is where I made the choice to proceed sui juris because I have my own best interest in mind. And it seems that the public defenders that were appointed to me were not assisting me effectively. And this was recreating a manifest injustice. So now I have received it a few days before we're supposed to be going to trial. I have reviewed the footage, and there is fraudulent and misleading statements made by the trooper that I have already submitted a motion to suppress that evidence that I'm sure the court will be getting shortly.
So we're a couple weeks before trial, or before confirmation. We've got trial scheduled the 18th, so we're 3 weeks out. All right.
Yeah, I would ask the court that either the prosecutor or counsel be sanctioned or some remedy be met for the